Good afternoon, everyone. As chair of the Historical Society of the New York Courts, I want to welcome you all to today's program, where we'll talk about the lessons we can learn from the 1918 flu epidemic. First, I just want to make sure that you are all well. These are difficult times. I particularly want to thank our judiciary in the state of New York, who have done an extraordinary job in these times. You know, many of us understand that judges and their staffs are working on the front lines of creating a virtual court system. And we all have much that we can learn from what happened in 1918 and as we do this. Just a bit about the Historical Society. Our mission is to preserve and promote the extraordinary legal history of our state. And I encourage you, if you're interested in our work, to visit our website, which has a wealth of materials about the history of New York and its court system, and also to sign up for our publications. I would also like to thank the Patterson Belknap firm for sponsoring this webinar. So let's begin. Let me first start by introducing our distinguished speakers. We're very fortunate to have Sandra Opdycke, who is the author of a leading history on the 1918 flu epidemic. Thank you, Sandra. We also have with us Ernest Abbott of the Baker Donaldson firm, who was a former General Counsel of FEMA. Finally, my colleague Muhammed Faridi, who's the author of a number of materials and articles on COVID-19 and is a leading commercial litigator. So as background, let me set the scene for you. As a part of history, pandemics have affected us for many, many centuries, decades. We can go back even to the Old Testament, as many of us are realizing. But I'll start with the year 430 BC. Athens was struck by a plague while the Spartans were laying siege on the city. So these events are things that we've had to plan for many, many times in our world's history. As we jump forward to 1918, I'd like to just set the scene for you. The world was still at war in Europe, what was then known as the Great War. And interestingly, as you'll see from Sandra's book, which has a very helpful chronology that you can get on the link, despite the name of the Spanish flu, as you'll hear, this outbreak actually is believed to have begun early in 1918 in Haskell County, Kansas. So with that background, Sandra, could you please describe for us how the 1918 pandemic began and how it spread more broadly through Europe and elsewhere?
It started in late winter of 1918 in this rather rural county. And if it were ordinary times, the flu might very well just have run out of people to infect and die out. But there were some soldiers home on leave, and they caught the flu when they were in the county, and they took it back to their base, their military base, where it took off. Then the military was transferring people around the country to other bases, so they took it with them, and then it would spread from them to towns nearby. Then the soldiers, American soldiers going to Europe, took it with them to Europe, spread all over Europe, both armies on both sides and the civilians. Now, all this time, it was pretty mild, and none of these warring countries were all that interested in talking about, look, we've got this disease that's romping through our armies and our civilian workforce. So they did not say much about it in the papers. Then the flu got to Spain, which was not in the war. Spain had no reason to keep it quiet, so the Spanish papers covered it a lot. So that's the first place that a lot of people read about it. Later on, when the flu got much worse, what people remembered was seeing about it in Spain in June. And so that's how it unfairly came to be called the Spanish flu.
Okay, so let's just look at a few numbers. And obviously, we are all impacted every day by the numbers we see on the TV. Millions of cases worldwide, hundreds of thousands of deaths. Just give us a comparison in terms of numbers. What were the numbers like in 1918 as compared to today?
They were much, much greater. Over the course of a year, which is how long this epidemic lasted, between 50 and 100 million people died, which is, many, many times what we have seen so far. They estimate perhaps 25% of the world was infected at one point or another. In this country, 675,000 people died, which is more than all the soldiers who died in combat in all the wars in the 20th century.
So why were the numbers so high in 1918?
Well, I think the war had a lot to do with it. There was a pretty, what seems to us like pretty heedless transferring of soldiers back and forth to bases, even while epidemics were raging on the base, then shipping the soldiers on crowded troop ships to Europe. And then obviously you're not going to do social distancing in the trenches. So
right. It's kind of difficult to do that, right?
And because we're going to, I think, talk about this a little more later on, but because of the war, they also didn't do as decisive a close down as we are doing, because they pretty much kept the economy going because of all these, because of all the military concerns. So that all fed it. And like us, they didn't have a vaccine.
So let's just stay a minute on the chronology. So it starts early 2018. We're still at war. Our soldiers are going back and forth. Nurses are, on the front lines. What happens in the...
But also supply ships going back and forth to European colonies all over Asia and Africa. So it went worldwide, really starting by June. It was all over the world.
It was a natural spread.
Exactly, international.
So international, I'm sorry, global. So let's come back, and after the summer, what happens when World War I starts to wind down in terms of, when our troops started coming home?
Well, before then, though, there was major battles in the spring of 1918, which kind of coincided with that, what we call the first wave of the epidemic. And by June, it pretty much seemed to be gone. And you would ordinarily expect, okay, maybe a year goes by and then you have another wave. In this case, 6 weeks later, in late August, a much more virulent strain of flu starts showing up. And that's the second wave. And that's the one that killed most people. And that's why we're all here. Not why we're all here, but that's why we're talking about 1918. Because of what happened in that second wave.
Comparing today, say we're in the first wave now.
Right.
When that second wave came, if we have numbers like this in the part of my hand for the first wave, what happens in that second wave in the fall of 1918?
Like your hand is how it went. It was many times steeper. It was a much more virulent strain. It killed more people. People got much sicker from it. So that was the one that really did the damage. And the war was going on through pretty much most of the second wave. And that was the really merciless one. And then there was a milder third wave that started in November, and that ran out in the winter of 1919, and that was the end.
So beginning to end, say about a year or so for the whole pandemic. And in that second wave, as we understand, the war comes to end. There's Armistice Day. What was happening that led to this spread, that led to this, enormous second wave?
Well, it was the third wave that was really kicked off by Armistice Day. During the second wave, people really were genuinely scared. And there was a good deal of efforts at social distancing. And we'll talk maybe more about how extreme those were, but that they were pretty careful. And then Armistice Day happened. They were getting tired of close downs anyway. We can all understand how that was. And
they probably had the word cabin flu, right? Or cabin fever, whatever it is.
Exactly. And then along comes Armistice Day, and everybody who's been careful about social contact runs out in the street and starts kissing perfect strangers. And thereafter, they pretty much closed down and ended the close downs. And a lot of towns, it was already over and they were okay, but there were enough communities where the epidemic wasn't really over to kick off that third wave. And it was by no means as serious as the third, but it was a good significant third wave, and it did go around the world again. And that was the end.
Now, epidemiologists are still debating about our current COVID, whether it's targeted at the elderly, and we've seen some reports about children. How did this 1918 flu affect people across generations? Is this something that only was affecting older people, younger people? What was the impact?
It was almost unheard of, and it almost spooked people because it was so different. The second wave went for was young adults in the prime of life. And of course, that's the soldiers. So that aggravated what was going on. One way people say it is this was an epidemic where children lost their parents, not their grandparents. Wow. And that's virtually unheard of for flu. And so that shaped everything that happened. It meant a generation of young wage workers, of soldiers, of young mothers died when you wouldn't have expected that.
Yeah, you talked about, the percentage coverage. I forget the number you used, 20-25% of the world's population. Did that lead, is it believed that led to some kind of herd immunity? We hear about that a lot. And how does that compare to where we are today in terms of the percentage of the population?
We are much, much lower. Even New York City, which has been harder than anywhere, isn't even to 2% or just past 2% of the population. Most of the world, most of the countries, it's around 1%. So that is far less than the 25%. Now we know that there are cases we haven't identified, but of course that was true in 1918 also. So I think it's fair to say that we're having far less prevalence than they had in World War I.
You started talking about social distancing. I think there was a term, crowding control. We're all now taught to wear masks. I won't hold mine up, but I encourage all of you to wear yours. But how did those kinds of things come about in terms of making sure that the disease didn't spread once people really got hold of it?
Well, one thing is who was in charge, and there was virtually no intervention from the federal government. There was a guy at the U.S. Public Health Service, which had a much smaller domain than CDC does today. And he pumped out volumes of sort of handbills and posters saying, put your hand over your mouth before you cough, and go to home if you're sick. But in terms of organization and direction, the federal government, which is totally focused on the war. I think Woodrow Wilson felt if he even talked about the epidemic, it would undermine public morale. So as far as we know, he never said one word in public about
But is it true that he actually almost got it himself?
He was very sick in the third wave, toward the very end of the third wave. And I think doctors are still arguing about whether that was flu or not. He had a serious stroke later that summer. And I think some people say it was a precursor of that, but it does look like flu. And Clemenceau and Lloyd George, who were at the same conference, each had about also. So it was definitely kicking around Paris. They called it the Paris cold. And there was a lot of that at the peace conference.
We talked about, the handbills. Obviously, that we didn't have the internet. We did have newspapers. How was the word gotten out that one should social distance, not, quarantine or whoever it was?
Well, there were, the local newspaper was more central to people's lives than it is now because there was so little else. And they had some information about what was going on in the rest of the world, but there was a great deal of information what was going on in your own town. And so you only had to look at 10 pages of obituaries. And there were often were these ads saying, you know, all these things about cover your mouth and don't spit and go home if you're sick. They had slides at the movie theater while the projectionist was changing role. But that's saying some people were still going to the movies, which of course would not be like what we'd be doing. It went city by city, it went state by state.
So it was a more localized approach to
Totally.
dealing with, and how about, were there quarantines?
Not anything that I think we would consider a quarantine. I mean, there may have been some towns, but in general, typically they kept the workplaces open, they kept the public transportation open, but they closed schools, they closed stores, or stores were off and on, but they closed all the recreational places, the places that would be fun, you know, the theaters, the movies. Hollywood actually shut down production for a month because there was nowhere to send the movies. So those kinds of things. Church services often met outdoors. Courts often met outdoors. I think, didn't you tell me, I think Supreme Court held oral arguments by phone, that kind.
Well, they have now. They didn't do it back then. They actually closed the oral arguments.
In any case, courts definitely.
I would think that the only time the Supreme Court is actually closed down, to our knowledge, except you know maybe earlier on.
Yeah.
But if you could, let's just go back to, you know, there's an image you can find on the internet of baseball players playing with masks. You know, there's would they still have events like that? You know, where you know you wouldn't have social distancing?
That's the irony, because there must have been people. I don't remember reading a lot about social distance in the sense we mean it, of sitting far apart. There was totally closed downs and there was outdoor events, but I think there was the idea that if you were outdoors, you were okay. So that outdoor things continued to happen. And of course, the most shocking from our point of view was the Fourth Liberty Loan Parade, which got tens of thousands of people in the street. In city after city all across the country, right at the height of what was theoretically the close down. So I think there was a sort of magical feeling and faith in fresh air.
So I think a lot of people were all wondering, you know, what's the next? You know, when are we going to start reopening? And everybody has these. In your own view, how did this come to an end? Did it just run its course? You know, was there, you know, we're all waiting for the vaccine. What's the lesson there?
I think running its course is the best expression. I think with 25% of the world having had it, you certainly had not run out of potential customers, but it had gone way, way down. And the virus became less virulent, which often happens when it has to live longer in one person in order to find the next one. And it just kind of petered out. Warm weather came, and that was the end of that season. There was another bad year in 1920, but it was nothing like 1919.
So, Sandra, we all want to learn from history. What would you tell people the principal lessons are to learn from the 1918 pandemic?
Well, I guess it's not over till it's over. It is one.
It's the Yogi Berra lesson, right?
Exactly, because I do think that people were not consistent about keeping the limitations, even their limited shutdowns, they weren't consistent. And at the time, it was hard to tell what was working and what wasn't because it wasn't wonderful data. But looking back, people can see that the cities that really closed down, at least in their limited way, when the first cases showed up, and really kept it closed until it really was on the downturn, did do better, did have fewer deaths. And I think that's the lesson. And then certainly the kickoff of the third wave says again that they probably reopened too soon.
Right. Okay, what I'd like to do now is to turn to you, Ernie, And let me just pick up with something that Sandra mentioned. And for those of you who got our invite, you saw a photo of actually a court proceeding being held outdoors. And, you know, I want to come back to our judiciary who's holding these proceedings virtually. They didn't have that ability back then, but they had the proceedings on the steps of the courthouse right in front. And if you look at the back, there are all these people crowding around them, not social distancing, not wearing a mask, etc. But you know, it would be helpful if, and you know, there was a mention of, you know, the Supreme Court canceled its proceedings. It would just be helpful for you to put this in context for us, if you could, in terms of the government response.
Thanks, Stephen. I'm not sure that I can add too much from what Sandra's already described in her session. I think it may seem a little bit trite, but the government entities were operating as best they could, given their understanding of the disease. You know, they did know that social distancing and masks were kinds of things which could slow the spread of the disease. I'm not sure they had a good idea of what else they could do to slow the spread of disease. Congress did close the public galleries. That's the public galleries. Congress continued to function. Their schedule was a little bit affected, but they did continue to function. The hospitals and the healthcare system were overwhelmed. But remember, so have we been overwhelmed in our healthcare system in the places where the virus has really taken hold. I think when you think about how we responded, you have to get your head back into the environment of war. During the course of the war, nearly 3 million men were drafted. Congress passed the Overman Act, giving the president unprecedented control over the war effort, from governmental powers down to production powers. So when you think about the control of production, there were some efforts to control the means of production to support the war effort. Congress was
And maybe I could stop you with that,
yeah.
Ernie. So, you know, we have a lot of discussion now of the Defense Production Act, which we know wasn't, you know, wasn't adopted for until decades later. How did they do that? What was the source of their power? How are these kind of powers being exercised?
That actually, in terms of what their power was as to enact wartime legislation, the one other act I wanted to mention, since we've also had some discussion right now about criticism of the administration, criticism of the federal government for what was going on, but Congress also passed the Sedition Act of 1918. To prohibit citizens from speaking out against the federal government and its political leadership in the war effort. And my guess is that criticism about the flu and its impact on the war effort might be deemed to fall within that. So not surprisingly, one could say that the response to the 1918 flu was left to the state and local governments. I mean, in terms of the wartime powers, the president is the commander-in-chief. In the time of war, you have the greatest opportunity to exercise those powers. Congress gave him statutes to exercise those powers. And you start getting into questions as to who is going to challenge it and how long it takes for a challenge actually to stop the administration's actions in support of the war.
Okay, so let's just flash forward a bit and use your expertise from FEMA. We now are hearing every day about these agencies with all these letters: FEMA, the CDC, the FDA. You know, what was the level of
what were they doing in 1918?
That wasn't my question. When you get back from the war and the war's over, how is this organized and what's the federal government look like? You know,
well, certainly in 1918 there was no CDC, there was no FEMA. I think there had been a long-standing Public Health Service Act. I think the first one may have been enacted in the late 18th century, very early 19th century. But the Public Health Service Act, as we know it today, was enacted in 1944. You know, so we did not have the structure of the federal government to try and take an active role with respect to the control of disease. I would say that no one at that time thought that it was, in fact, the federal government's role to be active in response, taking the lead effort in response to a disease. In 1905, the Supreme Court emphasized that the effort to protect the public from the spread of disease is the exercise of police powers.
And this is in the Jacobson case.
In the Jacobson case, and the police, although they were citing a long line of prior orders to that effect, and the reality is that the police powers were reserved to the states. They were not given to the federal government as part of the Constitution. So everyone thought that's where they should be.
Ernie, let's try to mine that a bit. The Jacobson v. Massachusetts, decided before this time a Justice Harlan opinion, they're looking at the reasonableness of restrictions like the kinds of things that we're going to be debating now when government does it. And you said there's no debate about federal state. How then does this get done? Does it get done every single county differently back in 1918, every city differently? What's the, how does this get rolled out?
Yeah, that can really depend upon the state and how the state has delegated its power down to local governments. In New England, where a lot of times there were a lot of cities that had significant powers of themselves, even before the full government of Massachusetts was established. It's sort of fascinating that the Jacobson case came out of an ordinance of the city of Cambridge. So in some states, it's going to be the local health officials. In some states, it might be a state public health officer. You will get differences of approach, and there were differences of approach in 1918. Different states cities did different things to try and prevent people from congregating amongst each other. I think it was Philadelphia did not cancel its Armistice Day parade. St. Louis did. It appears that showed up as or ended up having much greater disease in Philadelphia than had been the case in St. Louis. So there were quite a few differences across the states, and frankly, we're seeing the same thing today. There are some differences across the states as to the approach of how much is enough social distancing to protect the public health. And we will find out probably within the next year how, which approaches ended up being most effective, both from the standpoint of protecting the public health and also preserving as much as possible of the economy that we also need to survive.
So let's come back to Jacobson, which, as I understand it, is a vaccine case. What was the view of the Supreme Court and Justice Harlan in terms, because we're going to see these kinds of issues, to what extent can the state tell an individual not to do something that may impact someone else's health?
I mean, I think that the Jacobson case is a fascinating case. Henning Jacobson refused to be vaccinated despite the city of Cambridge's order. He also refused to pay the $5 fine, which is your penalty for not agreeing to be vaccinated. This went all the way up to the Commonwealth of Massachusetts Supreme Judicial Court and then on to the Supreme Court. Now, Jacobson had offered testimony at trial. He proffered it, that vaccination was unsafe and that it wasn't really effective, but the trial court refused to proffer. So he was not permitted to provide evidence on whether or not the vaccination was unsafe or effective. And that's one of the more interesting parts of the case is Mr. Justice Harlan said that was fine because everybody knows, and the courts can take judicial notice of the fact that vaccination is the safest way that we can be protected from the scourge of smallpox. And if we just had, some yokel doesn't know what he's talking about coming in to say otherwise, that shouldn't be changing what the courts are thinking about. But on the key issue that you were talking about, does the state have the power to infringe on Mr. Jacobson's individual right to the liberty of his body? It was really pretty clear. He said, upon the principle of self-defense of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. So he's basically saying that if it looks like there is an epidemic of disease and it needs to be controlled, the state has the power to take the steps which are necessary to do it. And it's interesting that creates a sort of a balancing test. What's the severity of the disease? How much of a threat is being made to the collective that requires them to defend themselves? And then how do you balance that against individual rights? And Harlan did talk about how, there is a possibility out there that sometimes there might be a circumstance or somebody might use these powers in an arbitrary and unreasonable manner, or go so far beyond what's reasonably required for the safety of the public so as to authorize or compel the courts to interfere for the protection of such persons. So you have a recognition that sometimes the state might go too far in defending its, exercising its collective right to self-defense, and then the courts would step in and try and control it.
And, to take that to the issues of, say, wearing a mask or social distancing, as opposed to a vaccination, how do you see some of those issues playing out legally?
Now, what's really interesting is I think it's pretty clear that wearing a mask, at least sounds like something which is a relatively modest effort which will have some effect at reducing the spread of the disease. And so I think it's clear in my mind that that is something that is a valid order. It got confused a little bit in 2020 with the CDC first saying, no, people shouldn't be wearing masks because the masks aren't doing anything to protect them. And then they thought, well, no, maybe citizens should declare masks, and because then they can prevent themselves from spreading the disease to others. But just the fact that you had a change in position on just that key issue of should citizens wear a mask might be something that could show up in a challenge to whether people ought to be wearing masks.
But how about quarantines and stay at home and closing workplaces? Why shouldn't I be able to go out and do my job and be able to earn a livelihood for my family?
The whole idea is you are a threat to others if you are spreading the disease. For this particular disease, particularly where it appears to be spread when it is asymptomatic, when somebody doesn't have any symptoms whatsoever, they can spread the disease. And so in that situation, the only way we know of right now, we don't have effective treatments for many of those who contract the disease. We don't know, we can't vaccinate for it. All we can do is try and prevent the virus from moving into people's bodies and infecting them. And in that situation, I think it's a fairly clear that social distancing, there is the power of the state to do it. And you have to do it consistent with the due process clause of the Constitution. Mr. Justice Harlan made that clear as well. Due process means, you can have a right to hearing, and you can have, and there's a substantive due process element to it. And so I think Muhammad's going to get to talk about some of the cases which are challenge some of those due process or bringing those due process claims.
So let's, you're in the disaster preparedness world and have been for a long time. what kind of lessons do you learn in terms of preparing yourself for these sorts of pandemics? What are the kind of best lessons learned from that we can take from 1918 and then bring it through some of the disasters that you've participated in helping solve for government?
Well, in terms of making the comparison between 1918 and now, and a lot of this goes back to the issue of the federal and state role. Back in 1918, there really was quite a limited federal role with respect to disease control whatsoever, and frankly for disaster response. There was no standing disaster legislation until 1950, and the Stafford Act, which is what's used now when the governor asks the president for help, please declare a major disaster. The Stafford Act was not enacted in 1974 and then amended with the name Stafford on it in 1988. So it's a new environment. Even in the Stafford Act, though, it is very firmly based in the principles of federalism. The federal government, the president cannot declare a major disaster unless the governor asks him. Okay, so the governor has to ask. The governor has to say, I have activated the state emergency plan. The situation is beyond the capability of state and local governments to respond. All of those are part of the gubernatorial request for a disaster. And I can't help but say what's really fascinating about this COVID-19 situation is the first federal action was when with respect to the Stafford Act, was a declaration of a national emergency is what President Trump called it, but it essentially was an emergency declaration under the Stafford Act without the request of a governor. And that is only permitted under the Stafford Act if the president makes a finding that this situation involves a subject area which is in the exclusive jurisdiction. It's the exclusive response or primary responsibility of the federal government to take action. And we have never had a declaration that protection of public health from a disease is either the exclusive or the primary responsibility of the federal government. Now, in this situation, the speed of transmission, I think, may have warranted that determination given under the Commerce Clause, presumably. But it does indicate how very different COVID-19 is and the 2020 situation from what it was back in 1918.
And just come down to the local level, many of us are impacted by the governor's orders, but how does that work now on the state level when a governor declares an emergency, and how does that interact with these local? Sandra was talking about how this city would do something or this town would do something. How has that changed from 1918 and from state to local?
I think that the primary authority remains the governor. Some governors, they actually have the authority to take control of the local governments. Generally speaking, when you have strong local governments, and New York is obviously one of those, that wouldn't happen. But the state governor can decide that they aren't going to take the action that's being recommended by the president. And there's Supreme Court precedent that says that the president cannot direct the governor to do something. The governor has his own public health responsibility, you might say, as the governor of the state, a duty to protect the public health and safety of the citizens in the state.
Okay, let me bring you to a final question on this subject. So we've started to see court challenges. There's a case out of Pennsylvania that the Supreme Court decided not to hear. Some of us are following what's going on in Wisconsin and the split in their Supreme Court. But can you bring us back to the Ebola crisis? There was a case of the nurse in Maine
That's
And
my
those of you who
favorite.
know me, Maine is a place that I actually kind of love. And those are the kinds of places that we'd love to all be social distancing in right now. But Judge Laverdiere in Maine, how did he address this? And what kind of lesson do you get from his?
I mean, this is my favorite case because of what Judge Laverdiere did. Now, Casey Hickox was a Maine resident. She volunteered to help treat Ebola patients in Africa for Doctors Without Borders, came back, was briefly quarantined by Governor Christie in Newark, and then went to her home in Maine. And she refused to comply with the quarantine. Now, she knew that Ebola was not communicable when there were no symptoms. And the fact that it's not communicable without there being symptoms was confirmed by the state public health official's affidavit to the court, which I thought was fascinating given the fact that the state public health official worked for the governor. And she was monitoring herself every day as a competent nurse by taking her own temperature. So she knew she was not communicable. So the court held that the state had not established that a quarantine was needed. You didn't have to order people who were not communicable, capable of communicating the disease, to leave their home, just to stay in their home, excuse me. But what he did do is he ordered that Casey Hickox continue her medical monitoring. I mean, she was already doing it, but she was now ordered to continue medical monitoring and then to report to public health authorities if she ended up testing positive of having the disease. Now, the reason I really like this case is because of the understanding Judge Laverdiere showed for both the challenge of public health decision-making and his sensitivity to the environment in which his decision was made. He spoke first, to Casey Hickox in complimentary terms about her service in treating patients with Ebola, the kind of service that we're seeing in doctors and nurses across the country today. He said, first, we would not be here today unless respondent generously, kindly, and with compassion lent her skills to aid, comfort, and care for individuals stricken with a terrible disease. We need to remember as we go through this matter that we owe her and all professionals who give of themselves in this way a debt of gratitude. Now, he'd also noticed that Casey had been on TV riding her bicycle with her boyfriend in flagrant disregard of the governor's order. And then he went on talking to her. He said, respondent should understand that the court is fully aware of the misconceptions, misinformation, bad science, and bad information being spread from shore to shore in our country with respect to Ebola. The court is fully aware that people are acting out of fear and that this fear is not entirely rational. However, whether that fear is rational or not, it is present and it is real, just like the fear of the virus today is real. Respondents' actions at this point as a healthcare professional need to demonstrate her full understanding of human nature and the real fear that exists. She should guide herself accordingly.
So a judge
really
speaking,
thoughtful remark. Yeah,
Ernie, a judge speaking directly to the litigant through their decision, please guide yourself accordingly. I'm not going to order you to do it.
You
and
win.
For those, I can't order you to do it. But, asking you citizen to citizen something, although a judge is that we all know is a somewhat different
Right.
citizen. And for those of you listening, it's in Ernie's article. It's Mayhew, M-A-Y-H-E-W, B. Hickox. I just want to briefly come back to you, Sandra, and could you just, weigh in on any of the points that Ernie has made in terms of, are there any other historical points that we should have in context, just so that, as we walk through this, if there's anything else from the history of 1918 that we ought to keep in mind right now.
Well, I thought one thing that was interesting was we do talk about how the federal government had no traditional role or small traditional role in public health at the time, but the president had taken on to federal government all kinds of other powers that had not been in the federal domain before. And I think it's reasonable to think that he might therefore have extended himself also to seeing this national crisis. After all, with 600,000 people dying in his country, that probably was appropriate for some kind of federal direction. And again, as you describe it with federalism, you wouldn't want them just pushing everybody around, but there was probably coordination that could have been helpful that they did not offer.
All right, let's turn to Muhammed Faridi. We're seeing so many legal ramifications of this, and I know, like many on the phone, I get a COVID-19 alert every 5 minutes, and many of them are quite helpful in terms of, you know, what impact we have on commercial transactions, what impact we have on local businesses and retail. There's so many ramifications of this crisis that we're going through. But can you just start us off? There were a couple of cases involving teachers and school drivers, and we know our teachers are, you know, having schools canceled. For the group, can you tell us, how did the courts deal with those sorts of issues arising out of the 1918 pandemic?
Yeah, so the effect of the Spanish influenza or the 1918-19 pandemic were as widespread as the effects of the current pandemic are going to be in terms of commercial transactions and the effect on criminal law and other aspects of our law. The two cases that you spoke about, Steve, these two cases came out, the first one out of Illinois and the second one out of Indiana. And in the first case, the Illinois case, this is the Phelps versus School District 109 Wayne County case. The state Board of Health closed the school system down for about 2 months on account of the pandemic, and the district refused to pay its teachers. So Gladys Phelps, the school teacher, sued the school district for her then salary of $50 per month that she said that she was entitled to. She was ready, willing, and able to teach, but for the quarantine order in Illinois, in that particular county at that time, that's shut down the school system. The case went all the way up to the Illinois Supreme Court, and the court ruled that where performance of the contract is rendered impossible by an act of God, the district is relieved from liability, but where the school is closed on account of a contagious disease or the destruction of the school building by fire, and the teacher is ready, willing, and able to teach, no deduction can be made from her salary for the time that the school is closed. So the court just drew a distinction between the types of events that could excuse non-performance. If it's an act of God, performance is excused, but if it's a contagious disease, performance is not excused. And interestingly, the holding implies that the spread of a contagious disease is not an act of God. And perhaps a court dealing with the bubonic plague or the Black Death plague from the 14th century would have come to a different view as to whether the spread of a contagious disease constitutes an act of God. The Phelps case, the case from Indiana across the state line, actually comes to a different conclusion. There, the municipality, I'm sorry, not the Phelps case, but the Gregg School Township case from Indiana, the other case that you mentioned, the court came to a different conclusion. There, the plaintiff school teacher sued the school district for the school district's failure to pay her the $3.25 per day for a period of about 27 days when the school was shut down because of the pandemic. The court denied recovery. It held that performance was made impossible by order of the health board's exercise of its police power to shut down the school due to the pandemic. So these are the two school teacher cases. The third case, this one involves actually bus drivers, school bus drivers from North Dakota. This is the Sandra case from North Dakota. In this case, it was a class action brought by the bus drivers who were seeking to recover compensation owed under a contract with the district that required them to transport teachers and students to the school. The bus drivers obviously couldn't perform under the contract because the school was shut down because of the pandemic. The trial court judge in that case instructed the jury that the bus drivers performed their legal obligations under the contract. If these bus drivers were ready to go to the pickup locations at a moment's notice when the school reopened, and the jury found in favor of the bus drivers and awarded them the $775 each that they were entitled to. The case went up to the North Dakota Supreme Court, which construed or interpreted the contract at issue between the bus drivers and the district. And the court noted that these contracts had differed from the contracts that the school teachers had with the district. The teachers' contracts specifically stated that they would be paid during the school term, even if the school closed down, no fault of the teachers. And this language was required in the teachers' contract by a state statute. The court held that or implied rather, that the district agreed to pay teachers during a pandemic, but the bus driver's contract did not contain such language, and therefore the municipality was under no obligation to pay them the monies that they claimed were owed to them. The court said that the drivers were paid for their service for driving, and they were unable to perform that service, and therefore no obligation to pay them. So you see courts from the same region, the Midwest, coming to different conclusions on issues that have facts that are in common.
And Muhammed, can I just stop you here? So you have three different courts taking different approaches to what we call sort of impossibility. Is there anything you can discern as, kind of doctrinal analysis about why courts in one jurisdiction in the Midwest are looking at these issues differently than another?
Yeah, and there are cases on this issue from other state courts as well, from New Mexico and Utah, et cetera. And in each of these cases, the courts come out differently because I think for two reasons. Number one, the doctrine of impossibility. It's a state law, it's a state common law doctrine, and each state has its own variant to the doctrine. And some cases turn on that particular variant that the particular court follows. I think the other, perhaps the more relevant and important consideration is it's just different judges and different courts with their different outlooks coming to cases with very similar facts in a different manner. The Illinois court and the Indiana courts, the two courts that were dealing with the school teacher contracts, were dealing effectively with the same exact issue. And the Illinois court found in favor of the teachers, and the Indiana court found in favor of the school district. And I think this is going to inform, or this is going to be relevant with respect to how we see litigation coming out of the current pandemic. There are going to be cases that are going to look very similar on their face, but the rulings will probably differ across state lines and perhaps even within the state.
And, we are a state that has 4 appellate divisions, and we are pleased to welcome many of our friends from across the state. We also all are in communication, many of us, with people that we hadn't communicated with since high school who may, be in the Midwest. And, one of the ways we've been able to communicate is with these kind of mechanisms. But they didn't have that back then. They didn't have Westlaw and they didn't have Lexis, where, were the decisions cross-referencing each other, or did they just each kind of come up with their own analysis? What's your view on that?
They weren't cross-referencing. Actually, the Illinois case, the Phelps case, is interesting because the court does do a very thorough analysis of how other courts throughout the country are coming to decisions that are in some respects very similar to the decision that the Illinois court came to, and in other respects came to different decisions. And the court does a very good job in distinguishing from those cases. So I think the courts during the time period were very well apprised as to what their sister courts throughout the country were doing and how they were dealing with the pandemic. And the courts did then what courts do now, decisions that align with the court's own viewpoint are cited as further support, and decisions that come out a different way are typically distinguished.
And that's exactly our judicial process that we learned from in law school and that great piece by Benjamin Cardozo. So many of us have heard this word force majeure, that, you know, we hadn't read this term as much, you know, as we're hearing it now, you know, as opposed to the school, you know, kinds of cases where you have public interaction. Were there contract cases, you know, dealing with things, you know, like supplying milk or supplying soap, or with the food chain and the supply chain that Ernie was dealing with, where, you know, someone doesn't want to perform under a contract, you know, a contractual analysis as opposed to this more impossibility analysis?
Yeah, I mean, there are dozens and dozens of cases from this time period that deal with contractual performance that are different from the school teacher and the bus driver cases. Actually, one of the cases is from 1914 or 1916. This is a decision from the Connecticut Supreme Court, the case of Whitman versus Anglin. And this case involved, did not relate to the influenza pandemic. It actually related to the hoof and mouth disease that is sometimes common in cows and pigs and goat and sheep. And there was a hoof and mouth outbreak in Michigan in 1914 that made its way through the Northeast in 1914-15, around that time period. And for those who don't know, hoof and mouth is, like I said, is an infection that's common and not common, but it's a viral infection in cattle and sheep and goats, etc., that can be very fatal to animals, and it's very contagious as well. So as a result of this particular outbreak in 1914, about 170,000 cattle and sheep and pigs were infected, and many died. In this particular case, the Connecticut Supreme Court dealt with a contract that required a dairy farmer to provide milk to the plaintiff at a specified price and at a specified location. And in 1914, the state commissioner of domestic animals, we had a commissioner of domestic animals at that time, heard that the hoof and mouth disease was prevalent in cattle owned by this particular farmer. And the commissioner ordered the farmer as well as all of his cattle to be quarantined. Shortly thereafter, all of the farmer's cattle died as a result of the disease, and the farmer was unable to perform under the contract. The court refused to excuse the farmer's performance on the impossibility doctrine, which is a doctrine that excuses contractual performance in some limiting circumstances. The court found that this was an absolute and unconditional undertaking by the farmer to sell milk at a specified price at a specified location. And the court rejected the farmer's defense that it was due to the order of the commissioner that he was unable to deliver the milk at the specified location. And the court said, look, the commissioner's order only quarantined your cattle and only quarantined you. It did not make the sale of milk by you illegal. And therefore, you cannot take refuge under the doctrine of impossibility. There's another case from Kentucky, the Napier case, Napier versus Trace Fork Mining from 1921. And that case involved a construction contract for a railroad project. And as a result of the pandemic at that time, the plaintiff in that case was unable to find labor needed to finish a project to qualify for an early completion bonus. And the court refused to apply the impossibility doctrine because the plaintiff merely showed that the completion was difficult and expensive because of the pandemic, not that it was impossible. So it's a pretty high threshold impossibility that states and state courts typically require the non-excusing parties to meet in order to excuse non-performance.
Let me just come back to one concluding case coming out of the 1918 influenza, and that's the Jiang Zhongwan case from the Supreme Court. There were a couple US Supreme Court cases, but I think this one may be the one that most of us can see a clear relationship between the pandemic and how the Supreme Court looked at that case. What was going on there, Muhammed, and bring this into focus for us?
Yeah, so that's actually a triple homicide case out of the Washington, D.C. area. And in that case, the police, along with some assistance from some federal authorities, apprehended the defendant and questioned him while he was suffering from influenza. And the case made its way up to the U.S. Supreme Court, and Justice Brandeis delivered a decision for a unanimous court. The court suppressed the confession that the defendant had made to the police authorities. And remember, this is before Miranda versus Arizona, which is the 1966 seminal case on the right to remain silent. And the court suppressed the confession on the ground that effectively it wasn't voluntary, that the individual, the defendant who was being questioned by the police authorities was suffering from influenza. He had very severe symptoms of the illness, which included vomiting and other types of details that the court Justice Brandeis explains in great detail. And this opinion, in many ways, laid the groundwork for the seminal case Miranda versus Arizona that came out in 1966. In fact, the Miranda court cites approvingly Justice Brandeis' decision from this particular case in finding a right to remain silent and also requiring the police to read out the defendant's rights when the defendant is under custody and subject to an interrogation. So the Spanish flu, or perhaps we should not be calling it the Spanish flu, because it apparently came into existence apparently in Kansas. I heard Sandra mention the cases or the flu, the pandemic had effects that were wide ranging, that affected municipal law, that affected commercial law, that affected criminal law, and many other areas of law that I think we probably won't have the time to cover.
Thank you, Muhammad. And if you look at these issues globally, very often our courts today are asked, how can I shift the risk of a loss from one segment of society to another? Are there any lessons to be learned here in terms of how these cases came out, in terms of that risk allocation?
Well, I think there's two things that really that bear on that particular point. One is you've got the development of this separate doctrine of force majeure that really developed a little bit later in the 1930s and 40s. The doctrine of impossibility, this is a common law doctrine that's been around for a long time. And impossibility is a defense to most the non-performance of contractual obligations. Force majeure is a contractual defense, and it is asserted to the extent that the contract allows for it, and the contract also sets forth typically the specific circumstances that need to take place. So it sometimes requires notice on behalf of by the non-breaching party. If the contract allows for it, this defense could be asserted alongside the impossibility defense. And the force majeure defense sometimes lessens the harshness of the impossibility doctrine. The impossibility doctrine it's a tough doctrine for the non-performing party. It's a very difficult burden to meet. And what you see here is, with respect to the force majeure doctrine, the parties in their contracts allocating the risk of loss among each other during when in a particular event that is specified in the contract. Let's say it's an act of God or a pandemic or an epidemic takes place. So that is a key lesson that comes out of the impossibility cases from this time period. The second is many states began to, in the 1930s and 40s, not most, but many, began to lessen the harshness or the strictness associated with the impossibility doctrine. And you see, number one, the American Law Institute do that with respect to the UCC, which does not require impossibility. It requires only impracticability, which is a lesser standard, a lesser threshold than impossibility. That's with respect to the delivery of goods. And many states adopting the impracticability standard with respect to the common law defense of impossibility, lowering the threshold from impossibility to impracticability in order to better allocate the risk of loss among the parties.
So let's just come back to circle the wagons. Starting with you, Sandra, if you were to give one sentence, or maybe we'll even have two or three, but what you think the principal lesson has been from the 1918 pandemic, so that the audience bears that in mind.
I think it's probably that public closings do matter. They did not do them as sweepingly as we have, but there is no question that the cities that began promptly and that stuck with it to the end had fewer deaths. And that is a lesson that I think we can learn and remember from them.
And Ernie, back to you.
One of the things that we talked about earlier is this concern about prejudice. I think some of the comments that we've seen coming in relate to that. There have been public health orders which appear to be motivated more by prejudice than by science. A famous case in 1902, whose name is escaping at the moment, is one where a cordon sanitaire, that's like putting yellow tape around an area and nobody can go through the yellow tape, and that's going to keep the disease inside the encircled area, and we won't have any disease getting out. So the city of San Francisco imposed a cordon sanitaire and said only persons of Mongolian descent are prohibited from going across the yellow tape line. Anyone who was not of Mongolian descent is permitted to go in and out of what was then Chinatown. And that was fairly obviously reflected a sort of a racial or ethnic animus, and the court struck it down even at the beginning of the 20th century. And we've seen a lot of concern now where people are acting out of fear. And the way in which you combat it is through public education and consistent, coherent public education. In disaster response, you have to have a consistent storyline about what it is that people should do to become safe, to be safe, to remain safe. There was a quarantine in SARS in which 30,000 were quarantined. They had not one single case go to hearing, and the reason was because of some very extensive public health communication programs. So you have to make sure that the message gets out, and gets out consistently, about what people can do to protect themselves, and that will stop a whole bunch of litigation.
This is a critical question about discrimination and how people are, maybe treated differently, depending on background. And, we've seen the whole issue about the Chinese flu. You saw the Spanish flu. Does anybody want to comment on these discrimination issues?
As Ernie mentioned, that 1902 case, it's worth reading, and we should send around the citation to that case, because the court, I think in a very bigoted way, basically said that, look, if you're a person of Mongolian descent, and that's not perhaps the right phrase or vernacular to use, you are quarantined. You cannot ingress or egress out of Chinatown. Meanwhile, other people who are non-Mongolian can go in and out. And I'm hoping and I expect that we won't see cases like that come out of our courts today. But in some ways, we have seen some news stories about people of Asian ancestry being treated differently. And we think that we've learned the lesson from our own history and how we've treated people of other backgrounds and different backgrounds before, but it's unfortunately a thing that continues to repeat itself, and sometimes it permeates its way through our legal system and through some of the decisions that do come out of courts. So I think all of us, litigants, judges, legal professionals, should be mindful of this particular issue.
Yes, Sandra, can I just come back to you? There's a question about science. We've all heard about science and so care about science. How can the science of the 1918 pandemic be used to learn today, and how can we use that, to use this, to get along as better people in our society today?
I am afraid that they operated without much science other than straight public health, which is public health is an important thing, but they had heartbreaking efforts to come up with a vaccine, again and again and again trying, and they were not too much into our rules for clinical trials. So they stuck God knows how many different preparations into how many different arms, but nothing really did deal with it. They did not particularly have any treatments. So it was really, sanitation was about the most science that was going on, I think.
So remember to wash your hands.
Incessantly. There's a nice story about a guy who said that the factory, which was of course still going near his house, would let out, and if any time that a worker spat on the sidewalk, his mother had a boiling kettle on the stove and she'd run out and pour boiling water on it. So I think that was kind of the level of sanitation.
Let me come back to you, Ernie. You talked about gubernatorial power. We've seen a lot of focus, following, Executive Order 202, number 1, number 2, number 3. Many of them deal with suspending local law, suspending state law, whether it may be statute of limitations, maybe there would be, the kinds of laws that we're used to operating under. How does that play out, in your understanding of an emergency? When you were talking about the strength of a governor's power, how do those executive orders play out, and what are kind of the lessons we can learn as a group from this?
I mean, the statutes that relate to emergency powers, state statutes relating to emergency powers, basically give an astonishing amount of power to the governor upon the governor's declaration of a state of emergency. Most of them are time limited. There is a limit that the powers are in effect for a period of time, after which the legislature has to approve it. But these orders, in a sense, give the governor the power to suspend law. So that's like the lawmaking power of the legislature is a key part of their constitutional power. They give the governor the power to spend money, just as the president's declaration of a major disaster suddenly turns on the disaster relief fund, which is kept adequately supplied with appropriations that they can be available to spend money in emergencies. Generally speaking, if you think about the power of the governor to go chase the bad guys, they can confiscate property. Remember all the movies where the policeman comes in and after they've seen the bank robbers run out of the bank and they jump into the car and say, follow that car. Well, that's commandeering the property of somebody else. So you have power to commandeer property. Generally speaking, if you commandeer the property to use it, you're going to end up having to pay for it under the fact that you can't take the property without just compensation under the Constitution. So there's a lot of ways in which the power of the executive is at its maximum in the heat of the response period. And it's also the time, I think, in which most people, at least if they know what's going on, are willing to cooperate. You don't have to order people to do stuff if they can understand what's going on and are able to do it voluntarily. Generally speaking, I would say if you're going to commandeer something and say, okay, you are ordered to do this, it will end up costing more money than if you persuade somebody, hey, it would be really important for the public, and you can demonstrate to your shareholders and customers that you have the interest of the public at heart if you will take this action, which was going to be of such great importance. I don't know
sort
if
of
that
like what the
gives you
main judge did in the Hickox
right.
case. Yeah, but if I could, because I want to come back to Sandra, was there any pushback from citizenry in terms of, do I have to stay at home? Do I have to wear a mask? Do I have to, not comply with an order?
I think there was not as dramatic probably as we have seen. And in some places, I think political leaders recognized that they would get pushback and didn't demand everything. I know they didn't require masks in Denver because the mayor of Denver said it would take half the population of the city to make the other half wear masks. And so there was that kind of thing that probably prospectively prevented pushback. On the other hand, San Francisco did make it mandatory. It was more, I think, a tendency of compliance drifting over time, more than outright defiance.
Interesting. So, we're trying here to learn from this. We had a couple of lessons of nurses that affected the women's suffrage movement. We didn't have the labor movement yet. We didn't have all the legislation that came out under FDR. Are there any lessons like that for women, for labor, for, if you look back at how our world is different today than, than it was back then, how do you comment on that?
One of the really impressive things to look at, and it's hard to recapitulate another time, is the dramatic role of women's voluntary groups. Partly because women were shut out of the marketplace in so many ways, women's voluntarism was probably at its fullest flower. And women's groups were absolutely central to getting their communities through. They drove doctors and nurses on their rounds. They ran referral centers. They ran canteens. They helped take care of kids when the parents were sick, and they organized. They didn't just do it, but they organized it. So that's really a really impressive thing to see. And of course, that is an era when women's voluntarism was so strong. And we really, I think as a country, we really benefited from it at that time.
And so, Muhammed, if I could, can I just ask you, there's a lot of, questions I see about communities of color. We've seen, for example, the enforcement of social distancing being disproportionately, based on the data, potentially, enforced in a different way depending on your background. We've seen the impact of this be squarely on communities of color in terms of the death rates. How does that shape, and how should that shape our views of what's going on today compared to, 1918, where we had, maybe people going back and forth on troop ships and things? What is your view of that?
Well, I think, Sandra is probably in a better position to talk about how that issue relates to what happened in the Spanish back in 1918. But as of now, with respect to COVID-19, I think all communities of color are very concerned about both the economic as well as the health impact that seems to be disproportionately affecting communities of color. So, this is an issue, I think all of us will need to study after this is over. I hope we can make some changes as we go forward, as we deal with this pandemic, although I am not too hopeful that we will see that. I think maybe after the fog is clear, we'll go back and look at how this could have been perhaps dealt with a little bit differently, that did not have such a disparate impact on communities of color. If I can just make one additional observation on the labor issue that you spoke about, Steve. The second wave of labor rights, the labor movement, you're right that it came really after the Great Depression. But the first wave began in the late 1890s, 1880s, when Eugene Debs was, a forceful figure in the labor rights movement. And you'll remember the Pullman strike from 1894, and Eugene Debs was convicted of the Sedition Act, which was passed in 1918 during the Spanish influenza epidemic. And some of these cases that come out of the Midwest, they are most of the decisions that came out actually were anti-labor in some way, pro-municipality, anti-labor. The one case from Illinois seems to be like an outlier, where the teacher was allowed to recoup her salary, or the school district was forced to pay her the salary that she was owed. And the opinions in these cases are devoid of any hint of whether or not the judges who were deciding these cases were affected in any way by the labor movement or the reaction that many people in that time period had to the labor movement. But that's what was happening in the background. And I think all of us know that sometimes things that are happening in the background do sometimes affect judicial outcome, irrespective of whether or not the decision maker is actually expressly citing or impliedly citing or acknowledging the outside actions in the decision.
Yeah, and thank you, Muhammed. Can I just come back to you, Sandra, because our healthcare workers have been extraordinary heroes. Tell us about the role of nurses. Did that have an impact on the women's suffrage movement in any respect? I know this is an area that you're particularly, attuned to.
Yes, I think the women's suffrage movement was just up and running by then. It was really, at full flower in any case. One thing that's interesting about the nurses is that when we entered World War I, a lot of RNs applied to be in the military nursing corps, which was seen as kind of a lead and a great way to serve. And the Red Cross was rather picky about who they took, and you had to have the right training in the right kind of hospital. But once the flu broke out in this country, then they cast a much wider net. And they did tremendous recruitment all over the country, sort of winkling every nurse out of her house to make sure that she turned out for service. And then they began campaigning for volunteers. They had posters saying a stern task for stern women, that was to line up women to volunteer. And so it opened much wider the gates of the opportunity to serve with the Red Cross as a nurse, including nurses of color who had been pretty much brushed off when the first military service was being organized, but now they were recruited in good numbers to help with the flu.
And unfortunately, we have so many questions. I would love to be able to take all of them, but Ernie, give you a last thought on, someone's asked about, federal monies going to states. Were there any kind of, issues like that went on in terms of the budgetary issues back and forth?
What's interesting, we haven't talked at all really about money issues. What is the Congress focused on? If they provided $2 trillion, I think so far. They've another big bit of tranches of money. State and local governments are incurring a lot of the emergency costs. One of the major roles of the federal government in all disaster response when the situation gets really bad is they provide funding, particularly to state and local governments. And a lot of that is to help. It's particularly critical in a quarantine type environment. Whenever you tell people they cannot go to work, you're telling people they cannot feed their families. So you have to think of, at least for those who are on a paycheck to paycheck kind of basis. And no quarantine order is going to prevent people from going out to try and get food or critical medicines if they don't have some system in which that is being provided either by the state and local government or through other sources. So always remember that the tighter that your quarantine gets, the more responsibility that you have to protect people who no longer have the means to take care of themselves and their families.
Well, thank you, Ernie, and we unfortunately have to wrap up, but I just want to personally answer a question that came in about court proceedings. If you look at the cover photo that came with this invitation, that was a court proceeding held on the steps of the courthouse with people walking around. I know we're holding virtual court proceedings, and we want to thank everybody in the legal community that's helped make these things sort of happen. But I want to thank all of you. I know that if we were here, I'd ask for a round of applause. We can't really do that in the way we normally do. For CLE, please email back your forms to the Historical Society. The email address is there. We have a wonderful website. If you have any questions about it, you can go on the website and find it. But I just think we've had such difficulty in these times, and it's so good that so many of us can come together on modes like this. We've seen there are so many similarities from today back to 1918, but also lots of differences because our country is in a much different place. So hopefully all of us have had some lessons we can learn from this. And finally, just on behalf of the Historical Society of the Courts, I want to thank you all for all you're doing for us, and really appreciate those of you who have spent the time to be part of this. And we will have a podcast, and so come back to our website on that, and you'll get that that information later. And but to wrap up, we hope you will consider joining us for future programs like this, and we hope that you will remain safe in the times that we're living. Thank you all so very, very much.
Thank you, Stephen.